Good morning, everyone. I'm Victor Siri. I run marketing here at PrimePoint. It's just a little past 10:30, and we have probably about half our attendees already logged in. On screen with me right now, you're probably seeing our presenters today, Judy Saylor and Ian McClinsky. I'll give you a little background on them in just a minute. But first, I want to thank all of you for attending today and say thanks for being a customer as well. And if you're not a customer yet, and you're attending today just to get to know us a little better, thanks for considering PrimePoint. We appreciate it. We do have a different approach that creates what we call the PrimePoint experience. And what I would like to do is play a quick video for you that gives you a quick recap of what the PrimePoint experience is all about.
Payroll processing, time and attendance, HR systems, and a different approach to customer service creates what we call the PrimePoint experience. From your first interactions with PrimePoint, you'll notice the difference. And once you become a customer, you'll experience the difference. Painless transition to our service, hold time that averages 7 seconds. You'll never be treated like a number. Get quick and accurate responses to calls and emails from live US-based customer support. Check it out at PrimePoint.com.
So there's a lot more to the PrimePoint experience, but we just couldn't fit it all into 30 seconds. And one of those things is our superior technology. So I would like to play a quick video for you that kind of gives you an overview of our latest and newest payroll platform.
Introducing PrimePoint's Business Access Payroll Processing Platform. Business Access is PrimePoint's premier platform for your payroll and HR management needs. To process your payroll quickly and easily, select your payroll date and add your worksheet. Add your hours or make any adjustments to salaries. Then simply calculate the payroll. The Preview tab has a variety of reports available. You can also review individual checks and compare your current payroll with your previous payroll prior to submitting. Approve and submit, and your payroll is done. Business Access was created to be a convenient and efficient platform for its users. Customizable dashboards on your home screen provide quick and useful information at a glance. Employee maintenance using Business Access is a breeze. Add a new employee or update employee information with just a few clicks. Reports are easy to access and simple to read. For more information or help getting started, use the contact form on our website, PrimePoint.com. We look forward to working with you.
Okay, so that's it for the commercials. Thanks for spending the time to watch those. It looks like we've got almost about half of our registered attendees online, and I see people are filing in pretty quickly. But to move along, I want to just quickly talk about the topic itself today, which is, you can see, is pandemic lessons learned and what comes next, and give you a little bit of background on our presenters. We have two experienced presenters today. Judy has a master's degree in management and organizational leadership. She received her HR certification from Rutgers and has been a certified HR professional since 2009. PrimePoint is lucky to have her in our HR support department. As you'll see today, she's a great presenter who uses her experience and her background to assemble and deliver a lot of valuable information in presentations like this. Ian is a Fox Rothschild partner. He's also the firm's lead attorney in labor law and employment law. And he's a lead attorney in a bunch of offices, the Atlantic City office, Miami, Princeton, Washington, D.C., and West Palm Beach. So he gets to travel around. Probably not so much lately, but before COVID, I'm sure he was on a plane a lot of times. He represents employers across the country and works closely with their in-house HR professionals as well as their in-house counsel to help them deal with labor law issues. So before we get started, I just want to point one thing out, and that's that you can ask questions throughout the presentation, and I'll be monitoring those questions, and I'll kind of break into the presentations by the presenters to present those questions and keep this a little bit more interactive than you might normally experience on a webinar. So you can use this box. This control panel should be on your screen. If it's not, you can use that little red arrow at the top, which will open up the control panel, and you can see where that question is, that question area where you can type in your questions. This session will be recorded, and I'll be sending an email out with that recording. And along with that, we'll be sending handouts, which will be mostly the slides that you'll be seeing today. So to get us started, I'm going to turn the presentation over to Judy. It's just going to take a second to make her the presenter. And we should be good to go.
All right. So good morning, everyone. Thank you, Vic, for that great introduction. Ian and I have been working on trying to stay up to date with what's going on with our latest labor laws. But to be clear, it could change tomorrow or this afternoon. So first things first, please be aware and understand that this is a presentation. If you have very specific questions, you should contact legal counsel or your HR support team. We're happy to help you, but we need to be sure we're getting the right assistance to you. So, Ian?
Right. Thank you, Judy. Vic, Judy, thanks for having me participate today. Our firm has been recognized nationally for our response to the COVID-19 pandemic by way of our client interaction, by way of daily and weekly alerts on issues that have developed since March. And what we've done is had a very robust team of labor and employment lawyers around the country tracking regulations, tracking government executive orders and directives, and we've been constantly pushing out client alerts on these various topics. At the end of the slides, there will be a link to our COVID resource page. You can go there and sign up for our updates. What happens is anytime we update the resource page, an email automatically gets pushed out with the update material for you. So that'd be a good resource. Excuse me. But as we got through the first round of federal legislation regarding the coronavirus, including the Family First Coronavirus Response Act, which we'll talk about in a moment, along with the CARES Act dealing with PPP money, we started a project internally to try to track claims made by employees and unions, and we'll press that a little bit later, with respect to how the plaintiffs' employment bar and unions are reacting to the new federal and state mandates. So we started an internal tracking project. We have a sophisticated in-house you would call it a library. We call it a knowledge management group. And what they've done is try to pull together data out there on employment lawsuits that are filed nationally, and we've tried to identify common scenarios and then identify these issues for clients. What we've basically done is used three what we call credible tracking services. These are commercial services that track litigations filed around the country, and we've also tracked federal and state court databases to find out what these court filings have been. And through that, we've identified some common scenarios and allegations by employees, and we've tried to determine what the highest risk areas are and try to work with our clients on developing preemptive, preventative advice. We'll talk more about some of the cases that we've seen as we go through the presentation this morning on various subtopics of interest. Judy, you're muted.
Thanks, Ian. I think that's
We're
going to be
back.
a project we're all going to want to read into. So where are we right now? And some of you may have seen this before. It's kind of my giggle at what we're doing. As of the moment, we're in stage 2, and that's orange. I swore I read somewhere that we were in red, or we were moving to red. However, there's so many things out there, it starts to become, a minutia of information. We're all still supposed to be having PPE, masks and gloves for our staff, 6-foot distancing and at your workplace. We have to be mindful of special circumstances, and we're going to talk about some of that today as we're moving on. When we look at where we were at, first thing that comes to mind is the FFCRA. This is in response, obviously, to the public health emergency. It's under Title I of the FMLA. Emergency paid sick leave was offered to assist working families facing this public health emergency. And of course, the coronavirus is the driver for a lot of what we're seeing right now.
So in connection with the Family First Coronavirus Response Act, as we commonly refer to it as the FFCRA, just for once, I would like Congress to pass a law that has an acronym that starts with Employers Headache Response Act. But here, the Congress came out with a piece of legislation that was signed by the president, and it provides certain benefits. And the first thing to notice about the law is it only applies to public employers and private employers with fewer than 500 employees, which originally was very shocking to employers because you would imagine that the federal government would put a burden and onus on larger corporations to provide a benefit. But the thinking behind this was larger corporations have a much deeper bench of employees and can be more flexible. As you get down to the 500 and below employee threshold, and I think we can make an argument that 500 is probably too high. Those employers have issues in providing paid time off and protected leave to employees. So that's what the focus was under the law. And under the FFCRA, certain businesses with fewer than 50 employees can exempt themselves from coverage under the law. That could be a whole program in and of itself. But fundamentally, the FFCRA has 2 key components. The first one is 80 hours of emergency paid sick leave. Now, for a small employer, this seems like an economic burden, but it really isn't, because the way Congress designed it is they're going to help fund it for you through a federal tax credit. So for any employee who is otherwise eligible, that you as a small employer under 500 employees provide these 80 hours of emergency paid sick leave. And there's a formula to apply for this benefit depending upon the nature of the leave. You then get a federal tax credit on your payroll taxes for that. So if you are under the 500 employees and you are paying out the emergency paid sick leave, you should speak with your accountants or your tax advisor to make sure that you get an appropriate tax credit for the money you're paying out, because it's being provided for by the federal government, backed by the federal government. And in certain limited circumstances, the the FMLA has been expanded to deal with emergency family leave under the FFCRA. Now, the odd part
if I
about
can break in for a second, we do have a question about the 80 hours of emergency paid sick leave.
Sure.
Someone is asking if the if that time is based on a calendar year, or is that a max per employee?
That is max per employee. And so if someone took 40 hours of emergency paid sick leave, let's say in June or July, they'd be entitled to use another 40 hours of emergency paid sick leave. But this entire benefit ends in 15 days. So if people don't use it by December 31st of this year, they lose the FFCRA benefit. This last bullet point in the slide is, then what? Our suspicion is that early on in the Biden administration, there'll be a push to do a few things. One would be to extend this FFCRA benefit to sometime in 2021. That is going to depend upon the makeup, I think, of the Senate, that we won't know until January. But with respect to this benefit, regardless of the 80 hours or the 12 weeks, it has to be all used in its entirety by December 31st. So just a little bit of background on the FFCRA. The FFCRA is a statutory benefit, but the statute provided that the United States Department of Labor would issue regulations regarding the application of the law. I, on behalf of a number of employer organizations in New Jersey, prepared a very lengthy letter to the administrator of the Wage and Hour Division of the U.S. Department of Labor, asking certain questions about the FFCRA and what the regulations would be, and providing certain solutions to issues. Happily, the administrator accepted most of our questions and most of our answers to those questions and adopted them as regulations. However, after the regulations were issued, a number of states, primarily the state of New York, sued the Department of Labor, indicating that the regulations were inappropriate for a variety of reasons. And the court actually sided with the state of New York. Did the Department of Labor listen to New York and the Department of Labor? Not really. What they did was, and the court, not really. What they did was they slightly modified the regulations to, I would say, finesse the regulations to come within what they thought the court's directive was. So if you look at the 4 bullet points here, these are important points to remember. So the regulations after this litigation reaffirm and provide additional explanation for the requirement that employee may take FFCRA leave only if work would otherwise be available to them. That's an important point. If the person's on layoff, on furlough, and they're not doing work, the FFCRA benefit is not available to those individuals. It also reaffirmed and provided that additional explanation for the requirement that an employee have employer approval to take FFCRA intermittent leave. If you look at the regulations, the initial set of regulations basically left it to the employee to decide whether or not they were going to take leave intermittently. Now you need it with employer approval, and this we'll get to later on when we talk about school leave as well. And they also revised the definition of healthcare provider to be specifically individuals that provide diagnostic services, preventative service, treatment services. In essence, the regulation was changed to be direct patient care. When you looked at the regulation originally, a healthcare provider was anyone working for, in essence, a healthcare institution, which even I, as an employer lawyer, thought was too broad. So the janitor, the receptionist, the groundskeeper at the hospital would be able to be excluded from coverage of the FFCRA, and I don't think that's what Congress had actually intended. And it also clarified that when someone needs to take FFCRA leave, they have to provide certain documentation to establish that they're otherwise entitled to the FFCRA leave. And that's also important because without that documentation, the IRS may not allow, or the Department of Treasury may not allow you to get your federal tax credit for the FFCRA benefit paid out. So that was an important clarification under the regulations. And if you take time, the FFCRA's regulations come in two types of formats. There's the 126-page regulation you can read, or you can read the 100 Q&As, FAQs that the Department of Labor puts out on their website. And when you do that, just note that in some areas, the regulations and the FAQs do not match. So what I would suggest is if you read an FAQ and you are scratching your head after you read it, you should look for that answer in the regulations.
Ian, before you go too much further, I do have a couple of questions coming in, and I think they're kind of both related to your previous slide. Someone's asking, you mentioned businesses with less than 500 employees. So we have a person asking, is that W-2s or FTEs?
So it's W-2 employees. So it's your head count. However, the issue with the 500 employees is that you have to measure the 500 employees on the date that the person asks to take their FFCRA leave, okay? So if, and it's the definition that's used for this is the definition under the Fair Labor Standards Act. So the problem with the definition, and I tried to get the Department of Labor to clarify this, but they would not, is that the FAQs, in essence, give the impression that it's complicated, so I'm trying to figure out exactly how to respond to this. When you look at the 500 employee head count and you look at you do it at the time the person is out on asking for the benefit. So if you have employees, let's say, who are on layoff, you're not counting those people. But then if you bring some of those people back, you may go outside the 500 employee threshold. So for example, I have a client who has 1,000 employees and they say we have 1,000 employees and therefore we're not covered. And the Department of Labor says, okay, but you brought back 490 employees. And when you brought home back 490 employees and someone asked for the FFCRA, they're eligible for it. And what we went back to the Department of Labor and argued that we understand that you're using the FLSA test, but the problem is that by doing that, an employer can come in and out of FFCRA coverage. It's not like the FMLA rule where you're looking at, do you have 50 or more employees and 20 or more calendar weeks in the current or preceding year, and then you have kind of a standard. So you have to look at the 500 employee threshold as to how many employees you have on the day the person otherwise would ask for the benefit.
Great, thanks. Then the other question relating to that topic has to do with the 80 hours. And this person is saying, our employees work 70 hours biweekly. I thought it was 10 days. So I think what they're asking is it 10 days or is it 80 hours?
80 hours.
And now another question.
And those 80 hours, Vic, are in addition to New Jersey earned sick leave.
Okay. And I have another question coming in asking, what is considered acceptable documentation for the FFCRA pay?
Okay. So the acceptable documentation depends upon the type of situation that the person is asking for FFCRA leave, whether it's their own medical condition, if it's a medical condition of a family member, whether it's a school closing or childcare closing, whether it's a quarantine order by a state or federal or local administrative agency. If you take a look at the FAQs that are on the U.S. Department of Labor website, there's Q&As for each one, and it actually sets it out. So what I would suggest to people, and this will get to a comment hopefully I'll make with respect to one of the slides we have in the future, is don't guess. Anytime someone comes to you and they say, this is what my circumstance is, take a step back, pull up the FAQs, see exactly what the documentation is. So for example, if the person is tested positive, you may ask them, okay, let me have the test result, then we'll pay you, and then you have the test result in order to substantiate your need for the federal tax credit. But it depends on what the reason for the leave is.
Thanks, Ian.
Now, Ian, I'm going to play devil's advocate. If we ask for the positive test result, aren't we tiptoeing into HIPAA?
So you technically are not. So here's an interesting point about HIPAA. Most human resource professionals and employees in general, anytime you hear medical, everyone says, oh, HIPAA. Mm-hmm. So you as the employer can always ask for a copy of the medical test result from the employee. If you ask the provider, the lab, or the doctor, HIPAA would prevent them from giving it to you, but nothing prevents the employee from giving it to you. The subsequent question is, okay, now that you got the test result, what do you do with the test result? And that should not be kept, let's say, in the employee's general personnel file, should be kept separate from it, because in the future you don't want a direct supervisor who has access to the personnel file to be making personnel decisions based on potentially a positive test result.
Okay. So now we start to look at those positive test results, and what has come into play now is workman's compensation. The definition of essential employees has changed pretty dramatically depending on what group you're into. Healthcare workers, obviously, public safety, certain transportation types of folks, hospitality or service industry workers. This other workers deemed essential starts to flood into the delivery groups, USA, UPS, FedEx, United States Postal Service. These are all, going to be questionable if someone were to apply for workman's compensation. Workman's compensation, the worker gets to pursue the workman's comp benefits claim if and while they were working away from home, meaning they did not work in their home and they went to an office or they went to their place of work, whatever that location might be considered. It is retroactive to 3/9/2020, which really does put a whole new spin on what folks have been doing with their employees. We know right now where people can be in their workplace, but our number keeps dropping as to how many people can be in the workplace. Essential employees are going to have the opportunity to apply for workman's compensation. However, it starts to look that if the employer is able to, and they're able to provide 50% backup to the fact that they provided a healthy and clean workplace, that their protocols were intact, that they were checking temperatures and doing all the appropriate steps at the workplace, then the employer can work to push back on that claim and potentially not have it be workman's compensation. The executive order that next comes is 192. It's for all employers, and it is the latest start of requiring masks in all places. I looked up, and almost 45 of our 50 states have a requirement right now to wear a mask in public or in the workplace. Some are a little more lenient and say it as a recommendation. The federal government guidelines say it's a recommendation. However, we're going to see this shift more and more as we're watching the virus change, our numbers. We see those going up daily. And yes, we're all excited the vaccine's here, but that's not going to be enough for us until spring. You can require visitors who come into your place of employment or work to be wearing a mask. We all have, I'm sure, seen the YouTube videos of folks losing their mind because they refuse to wear a mask in a public place or, like Walmart. For the employer, you need to provide masks for them. They do not have to be imprinted. They do not have to be pretty. They need to be a mask that can protect them, as Ian's giggling at me. You need to provide approved sanitation supplies. You can't go making something in your back office with rubbing alcohol and tea tree oil, for example, and put that out for your employees to use. You can put it out. They're not required to use it. You need to provide them appropriate materials for them to use in the workplace. So the continuation to that looks that we've got this requirement to ensure that employees are practicing hand hygiene. We've all seen the signs up since childhood of wash your hands when you're in the bathroom. We can be a little bit more serious about that. We need to clean and disinfect our areas that are high touch. The photocopiers, the coffee bar, door handles, anywhere where multiple people are going to be in and out of a place on a pretty regular basis. Prior to each shift, you have to conduct daily health checks, such as temperature screenings, visual symptoms checks. For many of you, if you have children, I know for my child's school, I have to go online to his student portal, and I have to attest to the fact that he has not shown any sign or symptoms or fever prior to dropping him off at school in the morning. And I don't always remember to do that, not gonna lie. However, we try to get it in there and make sure that it's clear for folks. Do not allow sick employees into the workplace. No, we don't know, and no one, you don't turn purple when you have COVID. You can have a cough, you can have a sneeze, you can have a fever. It could be something other than COVID, but most of us in HR have been saying, please keep the plague at home. Don't bring anything to the office. Most people don't want to share someone else's cold. We know how horrible that can be in the workplace. If you have employees that have been exposed by someone in your office, you can make them aware that there has been an exposure. I would personally err on the side of, I would not give people's names. That is up to an individual to make that statement. We've seen in the school districts that if there is a positive case, no one knows. That is not for the open, 8th graders to discuss amongst themselves. So the adults in the place need to make sure that they're on top of those things. You need to clean and disinfect in accordance with the CDC guidelines, especially if you have someone who has been diagnosed with COVID. There are thousands of products. I know everyone's having a hard time getting Lysol and Lysol wipes. We may need to work together. I know of several groups and organizations that are coming up with group bulk buying so they can get products. Lots of clients are selling things in a much larger product group than what we're used to.
Judy, we have a question coming in about an employee that tests positive. So they're asking if there's an employee within your company that tests positive, is it required that a workers' compensation claim be completed on the employee? Or does the employee also have to notify the employer that they tested positive?
Ian?
Two questions in there.
Yeah, so can you scroll back a slide or two to the workers' comp slide?
Mm-hmm.
Okay, so the bottom right hand, left right challenge. Bottom right hand, this essential employees or rebuttable presumption, right? So the general rule of thumb is that if someone reports to you that they have COVID, I would not in the first instance treat it as a workers' comp claim. And if the individual employee says, I got COVID at work, file a comp claim with your carrier. They're going to deny it from here to eternity. There's this bill that has been floating around and trying to establish that if you're a quote unquote essential employee, a first line worker, or worker in a supermarket, these definitions on the left-hand side of the slide, that there's a presumption, a rebuttable presumption, that you did get sick at work. The insurance industry is fighting that tooth and nail because it could potentially bankrupt them from a benefits perspective. So the short answer is I would not treat it as a workers' comp event unless the person insisted, and then I would file and let the carrier address it.
For workman's comp on the federal level, they're also saying that an employee who comes and says that, they need workman's compensation, they need to look at their position and say, are they at high risk? Do they come into contact with anyone else at work or during their daily routine with work? If they're not in a high risk position, the Fed is denying them workman's comp. So we're going to see a lot of gray zone with this as we move forward until we get some more of this legislation, defined and approved. Sorry, Vic, you had a question?
Well, I'm not sure exactly if they're asking this as part of this question, because at the end, the question is, or does the employee have to notify the employer? I'm not sure if that relates back to whether or not they have to notify him to get the workers' comp, or if they're actually saying, is an employee required to notify their employer that they were positive?
So I would say that if an employee tests positive, they would have an affirmative obligation to inform the employer that they're ill. Okay. Now, if you take a look at the executive orders, I think it's pretty clear that you're not, as an employer, you're not supposed to allow someone sick at work. I have to go back and read EO 103, 107, and 192, but I think that it would, in essence, the intent would be that the employees are obligated to tell you. Most employees who are sick with COVID don't want to come to work because, for most of them, if they stay home, they get paid to stay home. So I don't see an issue there. I think the issue is whether or not it becomes a comp claim or not. In the first instance, I would not treat it as a comp claim.
And on the HR side of things, we definitely want them to let us know. Not every employee is going to do something nefarious in order to be able to stay home. You work with great people. You don't want to get them sick. You may be positive for COVID. You don't want to be around anybody, so we've got both sides of the coin. We've got those who do it right and those who do it for different reasons. But it is something that you should encourage your staff to understand. They need to be responsible for their own health and the health of others. We all know that, just if I get sick, that it's not just me I have the potential to infect, it's everyone else that I love and care about.
Thanks, Vic. Oh, my favorite slide. If anybody leaves the presentation today and is interested in printing out any slide, this is the slide to print out. First of all, it's very colorful, but more importantly, it addresses the key issues that you have to pay attention to. The one overriding issue that Judy and I have talked about, and she's presented many a time as I have on these subjects, is that very often employers make uneducated decisions when confronted by an employee who's asking for a leave of absence for a certain reason. The gut visceral reaction is the employee is lying to me, this possibly couldn't be covered, and a decision is made before doing the full analysis. And as a lawyer, more often than not, when a client calls and says, here's the set of circumstances I'm faced with, and I say to them, okay, let me look at a couple of things and call you right back. The initial response is, what, you don't know the answer off the top of your head? And the answer is, a lot of times the answer is no. And the reason for that is this is not, by any stretch of the imagination, a simple, straightforward area of the law. You have multiple issues to address. As you see here, kind of starting in the lower left-hand quadrant, you have statutory entitlements to deal with. Now, we've already talked a little bit about the Executive Order 192. We've talked about the FFCRA, but there are others that you're going to have to take into account depending upon the size of your workforce. Are you covered by the Federal Family and Medical Leave Act, the FMLA, the New Jersey Family Leave Act, which is slightly different in terms of coverage on the employer side as well as the employee side. The New Jersey SAFE Act, which covers, let's say, domestic violence, court appearances relating to that. New Jersey paid sick leave / earned sick leave, depending on which nomenclature you want to use, and the FFCRA, which we talked about. Then you also have to, as an employer, take a look at whatever your policy commitments are. Take a look at your handbooks, any manuals, any policy rules or practices you have, and to the extent that you have a union, that adds a whole nother layer of, you have to look at your collective bargaining agreement, your labor agreement. Then you also have the obligation to make reasonable accommodations under both the Americans with Disabilities Act on the federal level and the New Jersey Law Against Discrimination on the state level. Judy, I'll talk more about that momentarily. And then you have to take a look at how you've treated other similarly situated employees so that you're treating women and men the same, whites and blacks the same, handicapped and non-handicapped or disabled people the same. And so what I say to people is, when you're doing a leave analysis, get a piece of paper, and on the left-hand side of your page, do a calendar of when the person's going to go out and what the anticipated timeout they're going to be. And on that side of the paper, figure out what their leave entitlement is under the FMLA, the New Jersey Family Leave Act, the FFCRA, the contracts, the handbooks, whatever. And then on the right-hand side of the page, try to figure out what their compensation entitlement is. I'm more concerned about the left side of the page, the leave entitlement, because that's not stuff that's easy to fix. So that's where the bulk of the focus should be. If you mess up on the right-hand side of the page, the ledger, which is the compensation, you can always fix that. It's money. It's fungible. You can pay it later. But you don't want to take an adverse employment action, decision against an employee based upon a need for a leave without doing the full analysis. And that means taking out the books, looking at your resources, making sure that you're a covered employer, making sure that they are actually eligible, that it is a covered event, that you have whatever documentation. So this slide, if you print it out and put it up on the bulletin board behind your desk, it'll give you a reminder of things that you need to look at each and every time someone asks for a leave. Judy?
So we start with FMLA then. It is 12 weeks of unpaid job protection. Let me say that again, unpaid. There are lots of employees who go, oh, well, I'm going out on FMLA, and assume they're getting paid. If they don't take those next steps, it is unpaid. One of the critical things that we in HR need to recognize is, once you identify an issue as an FMLA issue, you cannot decline it. The employee cannot decline it. There's a reason this was enacted, okay? It is for birth, it is for adoption, it is for immediate family members, it is for your own health. FMLA is for you. When we look at our next piece and we move into the qualifying reasons for FFCRA. Ian?
You're muted, Ian. I'm going to unmute you.
There we go. Sorry about that.
This we got to pause.
Coughing or sneezing. I don't want to interrupt Judy, so I apologize. So under the FFCRA, there are a number of qualifying.
Ian, before you go on, I'm sorry. There is a question I think that kind of applies to, it seems like most of what we've been talking about. This person is asking, are there any limitations or exemptions if an employer has less than 15 employees?
Less than
15 employees.
15. Unless you fit under the exemption under the FFCRA, you would, if you're less than 15 employees, you wouldn't have an FMLA obligation. You wouldn't have a New Jersey Family Leave Act obligation. You would be covered by the FFCRA unless you meet one of the very narrow exemptions. New Jersey earned sick leave applies. So am I missing anything, Judy? So it is possible that some of the leave laws, the leave obligation laws, right, the protected leave, FMLA and New Jersey Family Leave, and potentially parts of the FFCRA would not apply to you, but generally speaking, you're still obligated to provide the New Jersey Earned Sick Leave benefit, which is up to 40 hours a year. I hope that answers the question.
I think it does. Thank you.
So switching quickly over to the FFCRA, because I want to make sure we try to get through all of our material. There are a number of qualifying reasons, and there are a couple of things I want to point out about these. The first one, and it's what it was really designed to cover in the first instance, is the individual subject to a federal, state, or local governmental quarantine or isolation order related to COVID-19. That means an actual order, not an advisory, not a suggestion. So when someone, and we'll talk a little bit more about this later, hopefully if we get to it, is someone travels out of state and there's an advisory to self-quarantine, that on its face does not in and of itself trigger FFCRA payments, okay? However, if you get sick and the health department says, you're sick, stay home, yes, that would count under this first point, bullet point. However, if, look at bullet 2, this would be an individual, been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So if you do test positive and your healthcare provider says, in accordance with CDC guidelines, you have to stay home, then you are entitled to the FFCRA benefit. And then the third bullet point is the individual experiencing COVID-19 symptoms and seeking a medical diagnosis. So here's one where someone says, I feel sick, I'm going to go get a test. And, normally those tests, depending on which kind you take, you could do the rapid test, but most people don't spring for the expense for the rapid test. So it takes a good 2 to 3 days sometimes to get the results. That would be an FFCRA covered event. And then the next bullet point, if you're taking care of an individual who's subject to a quarantine order or has been advised by a healthcare provider. So my wife is subject to an order. My wife has tested positive and is homesick. I'm staying home. It qualifies under the FFCRA. The next bullet point, if my son or daughter's place of school or place is closed, or my child care provider is unable to take care of my child, it may be covered by the FFCRA. And this last bullet point, you can all ignore because The Secretary of Health and Human Services has been a little bit too preoccupied and has not come out with any additional qualifying reasons.
Okay, and I got a couple more questions that just came in.
Okay.
One person is asking if an employee is exposed to a COVID employee of a positive case, would all the employees be eligible to use the FFCRA?
So the answer is probably not all. I don't like using the word all. What you have to do, if one of your employees tests positive, step one, send them home. Step two, contact trace. And what does that mean? You have to figure out which one of your employees have, in essence, under I would say the then current CDC rules or guidance, because the CDC changes their guidance every now and then to match the scientific evidence, but in some cases, I think they're matching it to get public compliance. So when they go from 14 to 10 days in terms of quarantining, I think it's designed, they say based on the science, cynically, I would say they're trying to get people, it's easier to get people to stay at home for 10 days than 14. So you have to do this contact tracing under the CDC's then current guidelines. The current guidelines state has that you need to find the individuals that have been in close contact with that person. That means within 6 feet for combined 15 minutes over a 24-hour period in the 2 days, the 48 hours, either prior to symptoms developing or prior to the positive test for someone who is otherwise asymptomatic. You figure out who that universe of people are, and then the recommendation, at least from CDC, and I think by the governor's executive order 192, because it requires compliance with CDC guidelines, you would then tell those individuals you have to quarantine. And then I think under that set of circumstances, I think you would pay the FFCRA benefit. You would use the CDC guidelines in your contact tracing analysis to support actually the second bullet point on the screen here, because a healthcare provider, I would argue CDC would fall within that. You know, the idea is to not have people sick at work. I think it's worth the kind of pushing the envelope a little bit here on this point, because you are telling people to quarantine pursuant to healthcare provider rules. If someone is concerned about that, or an employer is concerned about it, I think it would be relatively simple to get a healthcare provider to establish that you should follow the CDC guidelines and send those people home. I don't think you're going to get a lot of pushback on that point.
So, Ian, on the issue of quarantine, there's another question here where someone is asking if an employee is exposed to a COVID employee, and can the employer bring them back to work sooner than the end of the quarantine period?
That's a dicey question. Okay. I would, and the advice I've been giving to clients is I would not bring somebody back to work sooner than what the then current CDC guidelines say. And my recollection is the current CDC guidelines say that somebody who is exposed should quarantine for 14 days. If they test positive, it's 10 days or 7 days with a test. I'd have to go back and literally I read it every single time. I would not bring somebody back prior to then complying with the CDC guidelines. I think you open yourself up for workers' compensation claims if they get sick or get someone else sick at work. There's all kinds of other claims that can arise in this context. And since if you're covered by the FFCRA, the government is in essence paying you to pay them, I would not bring the person back prior to the CDC guidelines.
So here's another question that just came in. What if an employee is living with a person who has been advised to quarantine while waiting for a COVID diagnosis? Do they qualify for FFCRA?
So the spouse, I'm just trying to think this through in my head. I don't believe that FFCRA benefits would apply to the spouse. Okay, if my spouse is sick, well, if my spouse is experiencing symptoms and is seeking a medical diagnosis, I don't think that that would then qualify me for FFCRA benefits. If she tests positive and I have to take care of her, then I would.
Okay. And one other question.
In that context, Vic, the New Jersey Earned Sick Leave most likely would cover the person for those, couple of days.
Great, thanks. So someone is asking a question back on the FMLA, and what they're asking is, do we have to do the normal FMLA paperwork for emergency paid sick leave and emergency family medical leave?
So for emergency paid sick leave, it's not an FMLA issue. Okay, it's more like New Jersey Earned Sick Leave. It's just a paid benefit. With respect to emergency FMLA leave, I'll call it, I would say yes, you should do the same paperwork. And the reason for it is you want to document ultimately that you gave the person the leave benefit so that they don't come back later and say, oh no, I was just taking my vacation and now I'm entitled to another 12 weeks of leave. So you want to document that to make sure that the person's using the time appropriately.
Okay, thanks. That's all I have right now.
Okay. So NJFLA, this is the part that is for someone else. It's 12 weeks in a 24-month period, meaning if they took time during 2020, they're potentially ineligible for time in 2021. This is done because we're definitely seeing a large uptick and folks are not able to double dip. They can't take this twice. They can't take their 80 hours twice. You can do it consecutively or intermittently, and you can require them to use PTO. When we look at the leave, again, it's unpaid, all right? Again, it's for bonding with the baby. It's not the birth of the baby. It can go consecutively right after your FMLA, and that's the hard part here. It is to care for his son or daughter or a husband, spouse, parent, etc. And we do see that in New Jersey, the definition for family changed. If you recall with New Jersey sick leave, it got much broader and much bigger. So FMLA only requires unpaid sick leave. The law permits you to require an employee to utilize their PTO, their sick time, vacation time, anything, some or all of it for their time off. Employees cannot use their FMLA for fear of getting sick. That's not an option. It's not on anything I've read. And the tough part becomes is there could be considered an indefinite leave of absence as a reasonable accommodation if this were to go to the ADA. And we'll talk about that in just a couple seconds. Ian?
Thanks, Judy. Two quick things. I just pulled up on my other screen the CDC website, and I think it's a good resource. We don't have a slide on it, but let me just tell you where to go. If you type in CDC coronavirus and general business FAQs, it comes up and there's a very good step-by-step Q&A analysis, depending upon what you're looking for. What happens if your employee comes to work? What should you do if you have an employee with a suspected or confirmed case? And it goes step by step through each scenario. And it's a really good tool to have on your desktop of your computer. So what I've done is there's a bunch of, the Department of Labor FAQs, the regs, the CDC guidelines. I have them all as shortcuts on my desktop. So every time I have a question, I go, I pop, I see what the most recent directive is from the agency and go from there. So it may be a good tool for you to have on your desktops as well. But the type of cases that we're seeing already, primarily in states like New York, New Jersey, the People's Republic of California, Florida, and even in the Republican stronghold of Texas, we're seeing a number of cases that have been filed already arising out of the FFCRA. And what they are is either denial of emergency paid sick leave or denial of this emergency FMLA for the most part. And they're really denial. Most of the cases are denial cases, which means that these are active employees who you have on your payroll who you're litigating against. There are a few cases where people have been terminated for making the request. Those cases are few and far between, but it's mostly the wrongful denial case, which puts an employer in this untenable position of having litigation with an employee who's currently working for the company, which is a very divisive work environment. We're not yet at the stage to tell you where these cases are going or what the courts are saying about them, primarily because most court systems have been shut down for a majority of the pandemic, and the case backload, it'll be years before these cases get to a jury trial, but they've been filed, they're there, and these are the common allegations. So these are things that kind of get to my comments regarding kind of like that really pretty slide that I've told everyone to print out about these are the analyses that you need to go through to avoid claims like this. No knee-jerk reactions.
Okay, I've got two more questions here for you. One person is asking, should you require an employee to get tested if they're experiencing any symptoms of COVID-19? So do you require them to do it?
You can require it. You can require it. I'm sure someone will ask this question towards the end. Can you require someone to get the vaccine, right? And it's kind of the same question. The answer is you can require someone to get a test if they're exhibiting symptoms. You can also require someone ultimately to get the vaccine. The caveat to both of those scenarios is if somebody comes forward and says, I'm not going to do it, the question is why? And if the reason is I have a handicap or a disability and I don't want to take the test or get the vaccine, Judy will talk more about AEDA accommodations. You have to go through that process. If the person says, I have a religious issue, my religion doesn't allow for vaccines, doesn't allow for certain types of medical testing, you have an obligation to make a reasonable accommodation for that. But then you can potentially put additional burdens on that person by saying, okay, well, if you're exhibiting symptoms and you're not going to go for a test, we're putting you on an unpaid administrative leave of absence because you haven't satisfied any of the FFCRA criteria, right? Because you're not waiting for a test result. You haven't been told by a healthcare provider to stay home, and it may be unpaid. You may have other pay opportunities for that individual, depending on how you want to interpret the earned sick leave law. If the person says, look, I'm not coming in today because I'm sick, then it would be New Jersey earned sick leave. But generally speaking, in the first instance, the answer is yes. But if they say no, then what?
Okay, thanks, Ian. And we do have another question. This person is saying that they're hearing of businesses closing because they had one employee who tested positive. They don't see anything on the CDC website around this issue, and they're wondering if there are certain requirements for businesses to close because of COVID.
Yeah, so there aren't guidelines and requirements in essence to close. Most of the businesses that have closed when someone has tested positive have primarily been in the food service industry, because they want to, because in that industry, kitchens tend to be very small and close quartered. They want to close for 10 days, 2 weeks, so that all the employees who are exposed to that other employee that tested positive it quarantines. And then there are CDC guidelines on cleaning of workplaces. There is an FAQ on their website in that business section about cleaning. And what it says, it depends upon the amount of time since the sick person was at the facility in terms of your cleaning regimen, right? So they suggest a certain period of time before you clean, and the type of cleaning that you do, depending on whether it's been less than 7 days or more than 7 days that the employee has gotten ill. But generally speaking, if someone at work gets ill, you do the contact tracing, you figure out who's been in quote unquote close contact. Those are the people that should quarantine. Anybody else, I would say come to work.
Thank you.
So on the New Jersey website, there is a COVID leave scenario sheet. It has, the last update was 4/16/2020. It gives you some very clear information on what is to be paid, and to whom, and the issue. We're starting with the schools because we do know that is becoming a big question. I see letters pretty regularly. You know, this school is closing for virtual. This school is moving to virtual. This school is moving to hybrid. We've got a lot of gray zone out there of what is the right thing to do or the best thing to do. And so this at least gives you an idea for your employees what you should be doing. Ian?
Great, Judy. You know, the back to the classroom or not, you know, I know from my kids are well out of public school, but a number of the people that work for me, their kids are in public school, and this is probably the biggest headache of all, more so than employees getting sick. Constant change in school, remote learning, hybrid model, back to school. And what I hear is that approximately 41 million workers have children under the age of 18. So that's, you know, a lot of workers who are potentially impacted by school change. And with respect to childcare programs, because of the financial impact early on in the pandemic, the statistic that was recently published is 40% of childcare programs are at risk of closing. So obviously this is a big issue that employers are going to have to deal with. And there's some application of some of the FFCRA to this. The magic of PowerPoint. School closures. So if you take a look at the U.S. Department of Labor's FAQs on school closures, and I believe they're FAQs 98, 99, and 100. So if you go to the DOL COVID FFCRA FAQs, this is all set out in FAQs 98, 99, and 100. If the school is closed and there's absolutely no in-person teaching, the parent, your employee as the employer, can take and is eligible for FFCRA benefits. That means up to the 80 hours of pay. And if the school goes this hybrid model where some days they're in person and some they're not, the FFCRA does apply. Now, where it says intermittently if approved by the employer, there's an inconsistency in the FAQs in I think it's FAQ 98, as opposed to the intermittent leave general rule that I think is rule FAQ 22 or 23. It's in the 20s. The intermittent rule says you can take intermittent FFCRA if it's approved by the employer. The school rule says if you have intermittent leave, you're eligible for FFCRA benefit on the day that the student is not in school. When you read those two together, it implies that the employer has to approve the intermittent leave, but I don't think that was the intended spirit of it. And quite honestly, most employers are going to be stuck accommodating, for lack of a better word, employees when their kids are on this hybrid model. But if the school is full-time in person, the employee is expected to come to work, provided the law allows them, because under the executive order by the governor and some other governors, if you can work remotely, you're supposed to work remotely. But if you can't work at all, then the FFCRA would provide a benefit under that set of circumstances. Is this one me, Judy, or you?
This is you.
Oh, it's still me. Okay, so in terms of back to school, some big red flags, and these are a lot of complaints that we've gotten from our employer clients over the last 6 months, is that, my hair's on fire. I have employees, their kids are staying home from school or my childcare, and how do I deal with this? And what I've said to them is, if you take a look at the cases that are out there, you are causing yourself a problem if you don't take certain steps. First of all, you better be flexible. You want to retain your employees. It costs a lot of money to recruit and train, and you want your employees to maintain their productivity, which means that disgruntled employees are not good employees, and then the problem you have is you're not getting your work done. So what we've suggested in a number of cases is that you conduct a survey of your workforce. Understand who's going to be impacted by school-related closing issues, and then develop a work plan, a program to address shortages of in-office or remote working staff who have this school-related closing issue or childcare-related issue. So that may require some capital improvements in the ability to people to work remotely. It may require that you have employees on more flexible schedules. So if the children are in school in the morning, but home in the afternoon, you may need to juggle and have employees in the office in the morning and work remotely in the afternoon. We do have a number of clients who have done on-site childcare, and where, in essence, they've taken conference room, plopped the kids, and have a couple of parents walk in during the day to make sure that the school-age kids are doing their schoolwork, and that the younger kids who are in, let's say, preschool aren't writing with crayon on the wall. I do not recommend this, but some employers have gone that route to enable their employees who are essential to the daily operation to come. But ultimately, and here's the biggest bullet point to take away from this slide, is when you're making decisions about treating people, this goes back to, again, that nice colorful slide in the lower right quadrant, that you're treating people similarly. You don't want to be treating women adversely to men. And quite honestly, I don't mean to sound sexist. If it comes out that way, I apologize. But it seems that in our society that the childcare responsibility still tends to fall on women more than men. And because of that, employers need to be careful about saying no to women to leave accommodations where a man would come in and say, ask for the same accommodation and be told it's acceptable.
So the rest of that wonderful document that the New Jersey has put up for us gives you an idea of what their expectation is if people are positive and they are working. If the person is out of work because the company they work for voluntarily closed, all the way down to freelance and independent contractors. This is a great document. I highly recommend you get it. It's on the front page of the disability website for New Jersey. It may change as we see workman's comp and potentially additional unemployment packages come out. We know the Fed is looking at this now. They're not looking at individual stimulus money. They're looking at supporting unemployment. So be looking for a new addition to this. And when and if one comes out, we'll make sure we get that on the website for everyone.
Yeah, and 2 quick points. That DOL sheet is also another document I have on my desktop as these reference tools. Yeah, I have 2 full columns down the right side of my desktop and my computer screen with all kinds of resources to quickly enable me to answer questions. So with respect to the FFCRA, there are things that you need to think about when you do this analysis. You know, it's just not sufficient to say, oh, they have this FFCRA benefit where they're getting paid up to 80 hours, but you also need to think about, does the employee have FMLA or New Jersey Family Leave Act time to use? Remember, FMLA, New Jersey Family Leave Act are leave entitlements where the FFCRA, for the most part, is a compensation entitlement. They can run concurrently, but in order to get the benefit, you need to document everything appropriately. So it's going back to that colorful slide, doing your analysis, doing your 2 tracks, leave compensation, and then documenting it out to your employees as to this is what you're entitled to. This is the leave under the FMLA, New Jersey Family Leave, and this is what you're entitled to from a compensation point. Your failure to do that is going to tee up a litigation. And this other question, can an employee get paid sick leave if your child's school makes your child quarantine at home for 2 weeks? The answer is yes. Under the FFCRA, if you're taking care of someone, you're entitled to get that benefit.
Now, when we start to look in a little deeper, we look at the Americans with Disabilities Act, the ADA. We know it's for employers with 15 or above. And it is a situation where the expectation or the accommodation does not damage the employer itself. The ADA can grant certain leave for individuals depending on their disability, obviously, to be in the workplace. The employer cannot set a maximum amount of leave. They can't say you only get 10 weeks, you only get 12 weeks. We are seeing people looking for an accommodation that will last indefinitely until there's a vaccine. So we've got to really look at every single one of our leave opportunities before we go, yes, you can have this, or no, you can't, and make sure that we're doing our due diligence on our end at HR, that we're protecting the company as well as the employee. It is a case-by-case experience, obviously, because a person's disability is unto their own. And some of the questions that start to come up is there, what is considered an undue hardship? And a lot of that you would want to go to legal counsel, and you would want to go to your payroll department and start to look at, is there a financial burden that we're about to have? You know, if our number one star person is now about to be out for an undisclosed amount of time, I may need to replace that person and bring in a temp. Now I'm paying 2 people, right? So we've got to look at, what does undo really mean for us in the long run? Ian?
Now that I've successfully unmuted myself, failure to accommodate. So this goes back to some of the issues that we talked about earlier. You know, somebody who has lung disease, diabetes, kidney disease, liver disease, who are immunocompromised, who have cancer, who are going through chemotherapy. These are all people that you need to make accommodations to, and because they have particular vulnerabilities to the virus. So if someone says, I can't come into the office because I'm immunocompromised, you know, you have to go through this interactive process, and you can't make it so that you're just dismissive. It needs to really be a interactive process between both you and the employee to see if there's some accommodation that can be made so that the person can work. The last place you want to be is before a jury in Mercer, Burlington, Camden County, Gloucester County, Atlantic County, and say to a jury of employees that it was an undue hardship for us to do X, Y, or Z, allow the person to work from home for a short period of time or whatever. You really need to roll up your sleeves and try to find a solution. And sometimes it may be different than work from home or come to work. It could be a hybrid. It could be working at a remote site, working at a location where there are fewer employees. You need to get creative. And if the failure to do that is going to open you up to a lawsuit that is a fact-based lawsuit that is going to require you is going to enable you not to get out of the case early, but wind up before a jury. So roll up your sleeves, try to find an accommodation to the extent you can.
When it comes to managing staff during COVID, we've done lots of presentations on this because it really is a very broad topic. One of the key pieces to look at here and to think about is the wage and hour implications for changing work arrangements. I've already had a client contact us to say that, you know, Dave ended up working overnight for them, so he's now expecting overtime, but he was not approved for that overtime. What should they do about it? And, you know, the biggest thing that you're going to go back to is your staff handbook. You may need to update it now, like today. There are lots of different opportunities that have changed, obviously. You do want to encourage things in a positive behavior, but with everybody working off site, how are you managing what they're doing? How do you know what they're doing? And we don't want to see folks go to the draconian measure of every hour on the hour you have to call me and tell me what you've been doing. But we want to be sure, one, that our staff are being successful working from home. And for some folks, they're not. And it's not them, it's all the other things around them. And they may say to you, can I please come back to the office? It may be better for them to come up with that type of an arrangement. The other concept is, you know, don't do blanket statements. You know, attorneys don't like the word all. Attorneys don't like the words everyone. You have to look at what are our prohibitions that we need to ensure, and how do we apply those appropriately to each case that may come up. You have to be very careful when applying any disciplinary action. Staff obviously talk, and they're definitely talking when we're not around. So if they're talking, then we've got to be clear on what is the appropriate requirement here, and how can we move forward with it. We don't want anybody not feeling good about work. We don't want anybody feeling, you know, that they've failed something. You want to, you know, praise in public and work together as a team with your staff.
So, Judy, in terms of, and to everybody, the overall fears here, right? People are very concerned about workplace safety. And there are a number of places where there are what I call pinch points that you have to really pay attention to. So in this environment, there are a number of circumstances where employees are coming forward saying, I don't feel I have the right PPE, not enough masks, not enough hand sanitizers. The signage isn't appropriate. There's not plexiglass shields. I wish I invested in plexiglass years ago. And employers are actually getting frustrated. And they're getting frustrated, but they're handling it the wrong way. Because we are seeing actions by employees who have raised PPE concerns or other workplace safety concerns, and they're filing lawsuits when they are disciplined. So in New Jersey, there is the SEPA law, which the Conscientious Employee Protection Act, which protects, in essence, whistleblowers. That has statutory penalties associated with it. We've seen some cases filed regarding wrongful termination for complaining about PPE. Also, if an employee complains about a dangerous condition in the workplace, they can file a complaint with OSHA. Oddly enough, OSHA has now started to investigate employee death cases. Let me rephrase that. COVID death cases by coming to the employers and saying, your employee died, prove to us that it wasn't work related. Okay, well, you're proving the negative. It's like, it's impossible. Mm-hmm. So OSHA has gotten a little bit more aggressive lately on that front because they got a lot of flack in a number of court decisions for not stepping up early enough in their investigation activities, their audit activities. There's a group of employees in a union who filed a lawsuit against Amazon in New York regarding lack of PPE at a warehouse site, distribution facility. The court case got thrown out because the court said it's not the court's purview to deal with dangerous conditions in the workplace. It's really the purview of OSHA. And then OSHA finally steps up and starts conducting more investigations. This next one is a big issue that I think people should pay attention to. People hear the National Labor Relations Act, the National Labor Relations Board, unfair labor practices. They think, oh, it only applies to unionized workforces. That's not true. It applies to what's called protected concerted activity. That means when an employee or group of employees advocates on behalf of a group, that activity is protected by the NLRA, and the individuals can file an unfair labor practice complaint with the National Labor Relations Board. How do you know if you have protected concerted activity? I'll give you two quick examples. If an employee comes to you and says, you're not giving me appropriate PPE, that's not protected activity because they are complaining about their own circumstance. If they come to you and say, you're not giving us, the employees, appropriate PPE, then that is protected activity under the National Labor Relations Act. And if you take an adverse employment action, it gives another avenue for that employee to pursue. And then on the ADA front, going back to what Judy had talked about, look, if someone says, I can't wear a face mask because I have a respiratory issue and it gets in, and the mask causes a problem, okay, well, maybe they have to wear a face shield as an alternative. You have to go through the accommodation analysis. And then finally, you have to take a look at state and local executive orders, because with respect to workplace safety, there are requirements in the EOs to require work from home and to require PPE. And if you read them very carefully, it allows the state in certain circumstances, either through the Department of Health and or the Department of Labor, to shut down your place of employment. That is incredibly difficult and bad for an employer, because then you have to petition the agency to reopen or go to court to get it overturned. You're out of business during that time period, so compliance with the EOs is critical. And I notice we've hit a brick wall. In terms of wrongful termination actions, RIFs have been one of the other areas of concern. Companies have done these reductions in force. There are two types of claims that have come out of them: pretext actions primarily, where employees say, I was included in the reduction in force as a pretext for covering up, in essence, my termination because I complained about PPE or a safe working environment. So therefore, what you really need to do is, if you're going to do a RIF, is roll up your sleeves, come up with a plan that is legitimate business protectable reasons, objective reasons. And then you want to make sure that you do an analysis to make sure on the back end that your plan doesn't have a disparate impact, adverse impact on a minority group, a group who's got disabilities, etc.
We're just about done, folks, so just hang in there for a minute or two. The steps on the HR side to avoid a lot of these violations that Ian has been describing: use a time tracking system. Don't just rely on paper right now. We're in a much different place than we were, in February. Ensure that your managers understand and know at least the Reader's Digest version of the FFCRA. If they don't, make sure they know to call you first. They should not be giving out information or making decrees when they might not have all the information at hand. And exhaust all the leave options. We need to do our due diligence. This is another point in time that HR and legal really need to walk hand in hand with this and go through all the steps, check all the boxes against what an employee could potentially have. Travel restrictions, we talk a lot, and at least at PrimePoint, because we have folks that live in other states. Our HR director, really is on top of her game, and every week we get an email out that says, what are the changes? Today you can go to Pennsylvania. Tomorrow you might not be able to go to Pennsylvania, or you may be able to go to Pennsylvania, but you have to have 2 weeks of quarantine. You've got to stay on top of that. And as HR, you have got to constantly communicate this to your staff. They don't know. If they watch the 5 o'clock or the 6 o'clock news, they're going to get conflicting information, and they're not going to know what their actual responsibilities are. Right now, we're at a point where the current and the coming challenges are going to change the landscape yet again for us. We know that, the latest piece that we've seen come out of the White House is they said if you are over 65 and have significant health conditions, you should not enter an indoor public space where anyone is unmasked. Guess what? That's just about everywhere. There are still folks who have not figured out that the mask is the thing we should do right now. And that's okay. Everybody will come to it in their own time. When they start saying that a whole age group should be staying away from something, we know this is much more serious than just what they say on the news every day. So we both, Fox Rothschild as well as PrimePoint, have coronavirus resource centers. We are going to send out the email to you with all of the PowerPoint. So you'll have these links to go to get more information. We update it pretty much weekly at this point, depending on what goes on with the governor and the federal government. And I want to thank you for all of your time today. Is there any other questions, Vic, that we need to look at?
I did hold on to a couple because we were running a little late. One person is asking, we're in Pennsylvania. Does this all apply to us as well? We do not have paid sick leave in Pennsylvania.
So the FFCRA would apply because it's a federal law. The FMLA would apply. If they have no employees in New Jersey, the earned sick leave wouldn't apply. The New Jersey obligations wouldn't apply. However, in Pennsylvania, you do have to deal both with Governor Wolf's executive orders as well as municipality executive orders. So if you're in the city of Philadelphia, you have to abide by their the mayor's executive orders as well. And you need to take a look at those, just as in New Jersey, we take a look at the governor's orders, which trump municipalities.
And any employees living in the city of Philadelphia and working in the city of Philadelphia, there is paid sick leave for them. So you need to go and look at what is everybody's addresses, especially if you've got them working from home now.
And one of the other questions that I held on to was if an employee already was out for 12 weeks under FMLA, can they still be out 2 weeks and get paid under FFCRA?
Okay. All right. So this goes back to mixing apples and oranges. What you have to do is look at the leave entitlement first. Okay. If somebody has used 12 weeks of FMLA leave, let's say to deal with their own personal health issue in January, February, March of this year, and then in September of this year said, I need 12 weeks because my child's school has closed. The general answer is, generally speaking, the answer would be no, they're not entitled to a second round of 12 weeks. It's a cumulative 12 weeks. The issue, however, is what is your FMLA benefit year? Is it a calendar year? Is it a rolling year? Is it a look back year? Is it a fiscal year? Is it an employee anniversary year? So you have to look at the 12-week calculation in accordance with the FMLA regulations, which I also have on my computer desktop, to kind of determine whether someone has used or not used all of their protected leave time. The compensation component is a different issue. And there, if they used sick time or vacation or personal time to cover their FMLA leave in the past, and now they're taking FMLA leave for something that is covered under the FFCRA, they'd be entitled to compensation under the FFCRA for that leave time. But then again, you as the employer would be entitled to a federal tax credit for the money paid out under the FFCRA. That's why I say it's much more complicated than people think it is. You know, Judy and I, you know, when we are posed with these questions, we actually look at the facts, look at what laws would apply, you know, basically graph it out, take a look, and it's a very complicated analysis, and that's why there's a lot of litigation so far, and my suspicion is there'll be a lot more litigation in the future about how people were treated during this pandemic for these benefits.
Okay, I just got two more questions here that we can get through pretty quickly. One is, if a New Jersey resident is working in PA, are they eligible for NJ paid leave?
No. It's not the state of residence, it's the state of work.
Okay, and last question is it rolling year for FMLA or calendar year?
The answer is it depends what your policy is, right? So under the FMLA, an employer has certain, I mean, this may shock people, but you have certain rights under the FMLA. And one of the rights you have under the FMLA is to pick a benefit year. And there are options: anniversary year, calendar year, rolling year, okay, or an alternative. And once you pick that year, that's the year you can use. The problem is, if you don't pick the year and have it set forth in your policy, when the employee needs the leave of absence, they get to pick the benefit year that best benefits them. And you are then stuck with it as the employer. So if you have 50 or more employees, and I'll say something about that in a second, 50 or more employees in this calendar year or last calendar year, and that 50 employees per week is not full-time equivalents, and it's not people you paid. The Department of Labor says if the person's name appears on the payroll, even in a week where they don't get paid, they count towards the 50. So you do the math. If you hit that threshold, you need to have a written FMLA policy and follow it, because then you can make certain choices that benefit the employer. Additionally, if you have 30 or more employees, you want to have a New Jersey Family Leave Act policy. And if you're covered by both laws, you want to make sure that the policy integrates both laws, so that when someone's taking a leave of absence that qualifies under both laws, you get credit for both, so that the person doesn't get 24 weeks of protected leave, they only get 12. So you want to make sure that you hit all the right buttons.
Okay, great. Well, I'd like to thank Judy and Ian for all this great information, and all of our attendees. Thank you for attending today. That's going to wrap it up. Some of you have already registered for our second and third sessions of this labor law series. And if you haven't registered yet, watch for emails coming out. We'll try to remind folks. The next one is on January 14th. And then the third one, I believe, is February 3rd. But emails will be coming out reminding you of those dates. So again, thanks everybody, and enjoy the rest of your day.
Thanks for having me.
Thanks.